Intellectual property can be an individual's or a business owner's most valuable assets. But many of us don't know exactly what is meant by intellectual property. How do we protect it? How do we enforce it? So today's video is going to give a basic overview of intellectual property law, and then some key concepts into copyright, trademarks, trade secrets, and then an overview of everyday situations where intellectual property may come into your business or your practices or even your dreams. Basically, intellectual property refers to the bundle of legal rights and protections that are afforded to the products of human intellect. Stated otherwise, it is how the law rewards and protects creativity and innovation. And in the basic sense, we want to encourage people to be creative, to innovate, to expand our technologies, to expand our knowledge base, come up with ideas. And this is the series of laws that protect those. But a key concept is intellectual property rights is not something that protects an idea. It protects the result, the product of that idea. And the general forms that we think of intellectual property would be patent law, copyrights, trade secrets, and trademarks. This video is going to be focusing on a few of these, mainly copyrights, trademarks, and trade secrets. Copyrights refers to the rights that are given to the authors or creators of original works of an idea or of artistic or intellectual expression that is put into a fixed, tangible medium. Once again, it's not the idea, it's the result of that idea. It's not the idea of that great novel you're going to write, it's actually the novel. It's not the idea of a song with a certain melody, it's actually writing that song and putting the melody together. Copyright is generally created, or you own a copyright from the moment of creation. When you write that novel, you have a copyright to that novel. But when it comes to enforcing that novel, or enforcing your copyright to that novel, or enforcing your copyright to a photograph, you have to have it registered with the U.S. Copyright Office. That is the key importance of registering your work with the U.S. Copyright Office in order to sue or to defend a lawsuit regarding it and to avail yourself to statutory damages. And I just want to talk about damages in general. The law tries, and this is a general concept of the law, if someone takes a right from you, the law tries to redress it by paying you or forcing the other side to pay you how you were damaged. But you have to prove how you were damaged. If you are an artist and you have a photograph and you're an up-and-coming artist, so your photography really doesn't have a value to it yet. Someone takes a copy of your photograph and uses it for their own. How are you going to prove how you were damaged? You don't have any other sales to use as a comparator. You don't have a list of customers that were going to buy this from you. So yes, someone took it, but how are you going to prove damages? This is where the concept of statutory damages comes into play. The law recognizes that in some instances it's hard, sometimes even impossible for someone, especially an artist, to be able to prove how they were damaged. So the law presumes a certain amount of damages that you can be awarded. You don't have to prove it. The law says if they violated your copyright, you're entitled to this amount of damages. But under copyright law, you can only do that if you register your copyright. So I know I went off on a little tangent here with copyright, but I want to summarize it by saying some key concepts of copyright. You own the right, you own the copyright from your date of creation. But in order to fully enforce and protect those rights, registration with the U.S. Copyright Office is key. Trademarks are probably the most familiar form of intellectual property. I think when I go talk to different people, they pretty much have a basic understanding of trademark, or when they say, oh, I need to protect my intellectual property, can you register a trademark for me? But just to back up for a moment, what a trademark really is, it helps secure your right or your business's right to use a word, logo, slogan, design, trade dress, a certain color, or whatever it is that distinguishes your goods or services from others, from using that similar mark in connection with similar goods or services. For instance, one of the classic example is the Nike swoosh. If someone sees that, they think of Nike. They think of Nike, you know, shoes, apparel, or whatever. And if you see a swoosh on a product that is not Nike's, you would probably be confused as a consumer that that was a Nike product. As the owner of that mark, Nike would not be too happy, and they would sue whoever it was that designed that t-shirt or used its logo to enforce its rights. That would be someone who's counterfeiting the good, taking advantage of Nike's mark to get you to buy their good or product by forcing you to think that you're dealing with Nike. How the law protects this is, as the owner of the mark, Nike has certain rights that it can prohibit you or someone else from using their mark. It can sue you and get damages. And when looking at this, what the law looks at are the marks, the Nike mark and then the alleged mark over here that another third party is using, are they substantially similar enough that it's likely to cause confusion in the marketplace? Is it likely for you, the consumer, to think that this person using this mark over here is really Nike? And if that's the case, then that person infringed on Nike's trademark. And so as a business owner, you're looking at where might you have trademarks and how does it come into play? It comes into play if you have a logo, your business name, if you have certain slogans you like to use. It could be in the packaging and the design. An example of this would be the blue Tiffany box. Someone sees a blue box in a certain shape or certain size. If you're the recipient of this box, you might get kind of excited because you know it's a Tiffany product or a Tiffany diamond ring on the inside. Tiffany has taken great efforts to protect that certain color blue in connection with boxes. So it's the key concepts for business owners to really understand is when you look at your products or services and how you display them or market them, to take a step back, pause, and say, which one of these are trademarks? It's not just it can be your name, your logo, your packaging, even some perfume, sometimes like a certain scent. There's, I think a certain card manufacturer had a smell associated that they placed in their card. So when someone would walk by, they would have a certain smell and it was associated with those cards. How can you distinguish your products, your goods or services from others through the use of trademarks? Your rights to a trademark stem from the moment that you first use it. So how copyright stems from the moment of creation, trademark stems from the moment of first use. However, how do you prove the date you first used it? And also keep in mind that trademarks are, you have federal trademarks, you have state trademarks, and you have what's called common law trademarks. So federal trademarks are registered at the federal level throughout interstate commerce. State trademarks are with each state, and common law are trademarks that aren't registered, but that someone has just used it over time. And even if someone just used it over time, they still have certain rights to it. So if you didn't register, think of two people who now claim the same right to the same trademark. Neither one of them registered it. And now the courts have to figure out who used it first. And you have to rely on the documentation and the honesty of the different parties and who has better proof as to when they first used it. The benefit of registering your mark is, and you register at the federal level with the U.S. Patent and Trademark Office, is that it gives you a presumption of your date of first use. So that if someone else comes forward with a date of first use on that same date or afterwards, your presumption is that date of first use is when yours is. So it helps you prove it and establish it and prevent others from using it who say that they started using it after your date of first use. It is, I guess, I hope I'm giving this the importance that it really is. And if you go back to the key concept of who owns a trademark stems from the person who used it first, to be able to prove the date that you first used yours is very, very important. And registration helps you to do that. Now, a similar issue with this is when you register your trademark, you register it per what's called international class. The U.S. Patent and Trademark Office have a class of goods or services. And you register your mark saying, I'm using this mark in connections with these goods or services. And your trademark protection and registration is only good for those goods or services. So let me give an example. If you register a mark in connection with education services, you can prevent others from using a similar mark in connection with education services. But you're not going to prevent others from using that mark in connection with t-shirt design. Unless that t-shirt design somehow is incorporating your education services, but assume for simplicity in the example on this video that has nothing to do with education. It's just a t-shirt goods and services that has zero. Your mark in education services isn't going to prevent someone else from using it in a different class of goods or services. So the takeaway from that is when you register your mark, consider all the possible ways that you're going to use your goods or services for that mark. It is common for people to register their mark in multiple classes of goods or services. If you initially only use it in connection of one good or service, that's fine. And if you expand later to others, you can always file additional registrations to additional classes or services later. But the key concept is know that the registration helps you prove the date of first use, but it's limited to the classes of good or services in which you register the mark. Trade secrets, it's whatever gives your business value in the mere fact that it's a secret. In the fact that it's not generally well known, that it gives you a competitive edge over others because no one else knows about this. A prime classic example of this is the secret formula for Coke. Coke chose not to get a patent for that formula because they want to keep it secret. They don't want it to be part of the public record. And to this day, people think of a trade secret, they think of Coca-Cola's secret formula. Other examples that maybe you don't have a secret formula for your business, but you may have some business processes in place that how you do things separate you from your competitors. You took time and effort to design this process. And because it gives you value and not many other people know about it, and you take efforts to maintain its secrecy within your business, that can be a trade secret. Certain customer list can rise to the level of a trade secret. If it's a customer list that anyone can get by just going through the internet and compiling information, contact information, that's not going to be a trade secret because that's well known, available to the public. However, if your customer list not only has contact information, but actually identified targeted customers on your own through your knowledge of meeting these people, understanding their preferences of your customers, knowing when they want to receive their invoices, knowing when they want to receive their product or services, knowing all the details that makes your relationship with that customer successful. Now that customer list rises to the level of a trade secret in most instances. But just calling something a trade secret as a matter of law doesn't make it a trade secret. there are some things that the owner of the trade secret must do. For instance, the two key concepts are, if the fact that something is a trade secret by the mere fact that it's a secret, the owner of it has to take efforts to maintain its secrecy and to enforce it. So if you are a business and you have a specific business process in place, but not everyone needs to know it. Your receptionist doesn't need to know it. Only high-level key executives or the people who implement the process need to know it. Guess what? Only those people should have access to it. Think of keeping your secrets under lock and key, limiting the number of people who have access to it. And if you find that someone inappropriately took it from you, they misappropriated your trade secrets, you need to enforce it. Failure to do any of these things can take something that was once a trade secret and render it no longer one under the eyes of the law. Trade secrets is unlike copyright, which is solely governed by federal law, and trademarks that has federal law, state law, and common law protections to it. Trade secret is more of a character of state law. So in Florida, Chapter 688 of the Florida statutes govern trade secrets. If you're in other laws, if you are in other states out there, you have state laws that may apply to your particular state. The business considerations for IP come down to two general concepts. Who owns the intellectual property? And if I'm the owner of the intellectual property, how do I protect it? Those two concepts come into play in different variety of scenarios. Think of one, coming up with your business name. Before you come up with your business name and try to register that with the Secretary of State of your respective state, design, marketing, programs and materials and flyers that you're going to go all out and do this once you register your business, only to find out 3 months later that someone else had the right and was using that business name before you did. To get a cease and desist letter and say, you know that business name that you just invested $50,000 on in your marketing campaign? Guess what? You can't call your business that. And if they're right, guess what? You can't call your business that. So that's step one in naming your business. Then when you get into, think of your business as running, it's operating, you're engaging in selling of goods or services, and in part of that, you're creating additional intellectual property. You hire an ad agency to do an ad campaign for you. They are the ones that put your idea, you come to them with the general idea of what you want the ad campaign to do. But that company is the one that puts that idea into a tangible form of expression. They're the ones that owns the copyright for it. They created it. Unless you made sure your contract with them designated that it was either a work made for hire or you were commissioning them for it and that you own the copyright to it. Meaning that even if you fire them later on, you have the right to the ad materials that they created for you and you purchased. If you have contractors working for you, say you're hiring someone to post stuff on your social media pages. Who owns the posting of it? They are the ones who are writing it, putting it into a tangible form of expression. They're the ones, if they're not an employee and you don't have it in writing as a commission for it, they're the ones that probably owns the intellectual property. If they are an employee, they may fall within the work for hire doctrine. But to avoid any confusion, even if they are an employee, I would specify that you, the business owner, is the one that owns the result of their social media postings, their articles, their designs, whatever. You also want to make sure that someone who is creating things on your behalf is not violating the intellectual property rights of others. So once again, the key concept of who owns the intellectual property. If I hire someone to do social media postings for me, and this person goes online and just copies someone else's photographs and put them on your website, and they didn't get permission from that photographer, and that photographer finds out, that photographer is going to sue your business for violating their copyright infringement. So you have to make sure that when you hire someone to do these things, that they know what they can and cannot do. And if it is another company or a contractor, you'll want to put some protections in your contract with them that, for instance, where they, guarantee or represent that they will not take other people's works, and if they do, that they will indemnify, defend, and hold you harmless from any claims that someone else has against you because of something that they did. So these are just a couple of areas where they come up as a business owner that you need to know.